Hello everyone, my name is Charlotte and I'm a solicitor in the private client department at Sweeney Miller Law. So today I'm going to be talking about succession planning, which all of you should be thinking about as landlords. So the importance of succession planning. So your property portfolio is not only a source of income for you, but is also a legacy for your children and family and loved ones. So with estate planning, you can do a lot of things such as mitigate inheritance tax, preserve that tax that you've saved onto your loved ones, and make sure that your wishes are followed. It allows for the continuity of your business and property, so there's no legal halts. So they're things that you can do with estate planning. On here, I've got the different ways in which you can own property. So if there's more than one owner, you need to be thinking how you own the property with the co-owner. So there's two ways in which you can own it. The first one is joint tenants. That means that you own the property as a whole. So if anything was to happen to you, your half share in the property would go to the other co-owner. So if you own any property with friends or business partners, it's vital that you check the ownership of the property. Because if you own any property jointly and you wouldn't want it to go to, for example, a business partner, you'd rather it go to your family, then the tenants in common option is the one that you need to make sure that you've got. So the tenants in common means that you own a specified share, so it can be 50-50, 70-30, 80-20, and it means that your share will go in accordance with your will. And if you haven't got a will, which I'll come on to in a bit, then it'll go under what's called the intestacy rules. So it's vital to make sure how you own the property. The importance of a will. So with wills, I think it's one of the most straightforward but most effective legal document you can have to do a lot of things. Firstly, which is what I think the number one factor is to reduce inheritance tax. It also makes sure that your wishes are going to be followed. If you pass away without a will, you are deemed to be what's called intestate. So you don't get to decide, or the estate or family members don't get to decide how the estate is passed. The rules are set out by the government, and that's what's called the intestacy rules. So it's a set of a family tree, and it's a set of hierarchy, and they follow down a tree. So if you've got any family members that you didn't particularly want it to go to, that's another key reason why you should have a will in place, so it avoids that. Another positive thing about having a will is if there's no one to inherit, your estate is what's called bona vacantia. That just means in Latin ownerless. So it means that your estate that you've worked hard for goes to the Crown, which I'm sure not a lot of you would want to happen. So again, another key reason why you should have a will in place. Another thing is if you pass away without a will and you've got children, your spouse wouldn't automatically inherit everything. They only inherit the first 322,000, and then if there's anything remaining, it'll be split between the children. So again, it's your wish that you'd want everything to pass to each other as a married couple first, and then the children, another reason why you need to have a will in place. Another thing I wanted to mention was just the common misconception of a common law spouse. I hear this loads. I get loads of clients ringing up saying, I've been with my partner for 10 years, they're not married, but they think they still have the automatic rights as a married couple. That's not the case in the UK, and we don't have that law. So if, regardless of how long you've been living with each other, if anything was to happen to you and you don't have a will, that's not what would happen in this case. So I had a client who rang actually a couple of days ago, had been living with her boyfriend for about 6 years. The property was in his sole name and he unexpectedly passed away. Under the rules of intestacy, his mum was in priority over her, which I'm sure would have been a shock to him. So he didn't have a will in place, so the mum was priority over the spouse. So that's another key reason why you need a will.
Excuse me.
Yeah?
On that last slide, what's that one piece of paper that Martin Lewis says could avoid inheritance tax?
The article essentially says it's a key legal document that you can have. So I'll go on to the inheritance tax bands in a bit, but there's ways in which you can broaden your allowances. So there's something called a residential nil rate band. Again, if you haven't had your will drafted properly, you're missing out on about 175,000 as a single person or 350 as a couple. So that's what he's getting at in the article. There's just certain allowances and trusts that you can do in the will to utilise the inheritance tax allowances. If you don't have that, you're missing out on quite a bit of allowance. As well as a will, lasting power of attorneys are up there, I think, with importance with wills. So what they are is a legal document which, if you were to lose capacity, it allows your appointed attorneys that you trust to deal with your affairs if you're not able to. So if you haven't got a lasting power of attorney in place, as landlords, what that means to you is that no one's got the automatic right to collect rent. So it could be, you could miss out on collection of rent, which could lead to repossession of the house getting sold. If you go away or you have an accident or you're unwell and you have a lasting power of attorney, at least you know someone's going to have that authority to deal and help with it for you. So it's key to have a lasting power of attorney. So there's two types. The first one that I've mentioned that all of you sitting here should have is a property and finance lasting power of attorney to make sure that the rent's still going to be collected and the property portfolio, the value of it is still going to be upkept, and it's the properties and things are not going to be in disrepair, and they can still do valuations and things. So property and finance lasting power of attorney is essential for everyone. The other one is for health and care. So it's for more personal decisions for if, for example, any surgeries or treatments needed to be had and you couldn't make those decisions yourself, your trusted and loved appointed attorney could make those decisions for you. This is a scenario here that I'm going to read out. Obviously, I haven't put any confidential details on here, but this scenario, I get loads of people coming in the firm with this scenario. So anyone sitting here could find yourself in this scenario here, which is what I'd hate for to happen to you. It can easily be avoided if clients like David had had a property and finance lasting power of attorney. So I'm going to read out the scenario. Because this might happen to any of you if you haven't got lasting power of attorney in place. So David, an experienced landlord, managed several rental properties, handling all tenant relationships, finances and maintenance himself. His spouse, Emma, had little involvement in the property management side of things and had minimal knowledge of the legal and financial details. They had never discussed creating a lasting power of attorney, and Emma thought she could step in automatically as the spouse if anything was to happen. So unexpectedly, David suffers a serious accident that left him incapacitated and unable to manage his properties. Without an LPA, Emma had no legal authority to access David's bank accounts, to pay for property maintenance, collect rent from tenants, or make decisions about tenancy agreements. Critical issues like repairs, rent collection went undressed, and some tenants began to withhold rent or vacate the properties due to unresolved issues. Realising that she needed the authority, she applied to the Court of Protection for what's called a deputyship order. So if you haven't got a lasting power of attorney in place, that's the route that your family would have to go, because you have to have capacity to put a lasting power of attorney in place, which David unexpectedly has lost, and he hadn't had it in place, so she's had to go through the court order for what's called a deputyship order. So essentially what had happened, the court process for a deputyship order can take anywhere up to a year. It's very complex, and they're very expensive and costly applications. So the tenants were complaining, repairs were missed, complaints piled up, and the properties became vacant and financially draining, and some of the properties actually had to be sold. By the time Emma actually got the deputyship order, the properties had suffered significant financial setbacks. Plenty of tenants had left the properties, which needed a lot of repairs, which she wasn't able to do because she didn't have the authority. And some of the properties were actually at risk of repossession due to unpaid mortgages. So what I'm trying to get at with this scenario is if David had a simple document, a property and finance lasting power of attorney, it would have saved Emma a year waiting for a court order. They're a lot cheaper than a deputyship order, and she would have been able to step in straight away. All right, so that's why I've put that in there. All of you should be thinking about putting a lasting power of attorney in place. It's never too early. Yeah.
Can I just ask, so is the property and finance LPA, is that one of the same?
Yes. So
I know there's in my head, I know there's finance and I know there's health.
Yeah, so if you've got the property and finance lasting power of attorney, it allows things even such as pensions, if you've got any private policies, money in the bank, ISAs, stocks, bonds, shares, it covers everything. Yeah. All right.
So property is part of the finance.
And the finance, yeah. So if it's all in one. So now I'm going to talk about the inheritance tax thresholds. So as a result of the recent budget, this is now actually frozen until 2030, so they're not likely to change until then. So it's key that you understand what each of the inheritance tax thresholds are. So inheritance tax, let's be honest, is one of the main reasons why people do a succession planning. I'm sure not a lot of you would rather your money go to family than in HMRC's pocket. Another reason why you should be looking at succession planning, because you can try and avoid and mitigate paying tax. So for a single individual, the inheritance tax band is £325,000, and for a married couple, it's £650,000. Like I mentioned, in the will, if it's drafted correctly, you can also get what's called a residential nil rate band. So that's if you leave your property to direct descendants. So that includes children, which also includes adopted children, grandchildren and great-grandchildren. Then you can get that 175 or 350 as a married couple. If you leave your property to anyone else, then unfortunately you don't get that residential nil rate band. Anything above those amounts, you will be taxed at 40%. So how can we try and mitigate this? So the first thing is making gifts to children. So as per the inheritance tax thresholds, you can gift up to £325,000 as an individual or £650,000 as a couple, tax-free every 7 years, and it's what's called a PET, a potentially exempt transfer. If you make a gift to your children or grandchildren or any other person over your allowance, your yearly allowance, which is £3,000, then it'll be taxed from when you made the gift to when you survived it. So it's what's called taper relief. So I've got a graph on here. So if you make a gift and you survive the full 7 years, that will form part outside of your estate, so there'll be no inheritance tax liability for it. If you survive between 6 to 7 years, then the tax will be 8%, 5 to 6, then it'll be 16, and then it gets more and more. If you don't survive less than 3, then it'll be the normal rate, the standard 40%. So there could potentially be inheritance tax on gifts. Another tax that you need to think of is capital gains tax. So if you're making any gifts to children, HMRC consider them as what's called a connected person. So it'll be the market value of the transfer. So capital gains tax is worked out by the value, the cost of how much it was to accrue that asset, minus the value of the transfer. So it's what's called the chargeable gain. So that's how that's worked out. Another thing I want to mention is, I know I've mentioned the 7 years. If you make a gift and you survive 7 years, it won't form part of your estate. That won't apply if you continue to benefit. So for example, if you gifted your main residence to say for example your daughter, and you survive 14 years. If you continue to live at that property, regardless of whether you've survived 8, 10, because you're continuing to live and benefit from that property, the full value will still be considered. So it's what's called a reservation of benefit. So if you're continuing to live there, regardless of when you've gifted it, the full value will be considered.
Wouldn't you be able to sort of pay a market rent for it though?
Sorry?
Wouldn't you be able to pay a market rent for the property?
So this...
And then it would sort of, you still get the benefit?
Yes, yeah, so this is in relation to gifts. So if someone's looking, so it's mainly beneficial for things like buy-to-let properties, not your main matrimonial home. So if you're looking to mitigate and downsize the value of your estate for inheritance tax purposes, it's best not doing your matrimonial home. The reason being because this reservation of benefit rule would come into play because you're continuing to benefit from the property.
But you can in fact get around that because what you can in fact actually do is that it can be transferred, but providing you sort of pay a sum in market figures, you will still have the benefit in that regard.
For capital gains tax, that wouldn't apply for inheritance tax. Obviously, you wouldn't be, if you're making a gift and you're continuing to live at the property, that full value, regardless, that there's no way around it. If you still continue to live at that property, regardless of whether you've gifted it to someone, because you're still living there, unfortunately, the full value of the property will still form part of your estate. There's no way around that.
Well, I have sort of seen the situation where that's actually been done. And what actually happens is that they pay the market rent for it, and they put around it that way. But having said that, it may well be a moot point.
It's still a reservation of benefit. If you're getting rent from a property that you've transferred, you're still reserving the benefit by getting rent from the property. Yes, that's right. Sorry, if you're paying rent.
Yeah, they shouldn't get the rent.
The next effective way to try and do succession planning is trusts. So trusts allow a lot of things, again, mitigates inheritance tax. It's also beneficial if you've got any minor beneficiaries, if you're worried. So the automatic age that someone will inherit is 18. If you'd rather stipulate to be a little bit older, then what you can do is set up a trust, and it's up to the discretion of the trustees to withdraw from that when they feel like they're ready and in line with your wishes. Again, it can avoid probate. It can also protect family wealth. So if you've got any beneficiaries, your children, who are married and they get divorced in the future, that inheritance that they receive could form part of their divorce financial settlement. If it's been put into trust, then that won't happen. So it preserves that family wealth. You know that your inheritance won't form part of any divorce settlements. Only thing that you have to be careful with is if you put the value of any asset, so property, above them inheritance tax thresholds that I mentioned, then there are certain charges. So there's a 10-year anniversary charge and there's an exit and entry charge. Them charges depend on the value of the property. So if you're looking to make any trusts, we would strongly advise you to go and see a financial advisor or a tax specialist to make sure it's the right option for you. On here, I've just got a checklist. I know it's quite a lot of information I probably gave you today. So feel free to take a picture. Something to think about when you get home. So I know it's a lot to think about. So moving forward, things that you need to be thinking about first is how you own the property. So is it joint tenants or tenants in common? If you own property jointly, then you need to be thinking about the different ownerships. If you own property jointly with a business partner and you'd rather it go to a family member, then you need to look at reviewing that. Next thing is creating a will. Like I've said, the benefits that come with a will. If you've already got a will in place, then you need to be reviewing it. I'd say at least every 3 to 5 years. or upon any life-changing events. Setting up a lasting power of attorney, consider gifting to children, or establishing a trust. If you get any of these documents, I would strongly advise you to get a solicitor to do it. It also allows to make sure that there's no potential claims against the estate because it's been properly drafted by a solicitor, and it's none of these homemade wills. I've seen absolute nightmares with them where they're not validly executed, and the rules of intestacy have applied because the will's not valid. So make sure you get a legal solicitor to do it. On here I've just got a quote. I know with succession planning it's one of them things that no one likes to think about, but if you get the ball rolling and start talking about things, then you know that your wishes will be followed. I've just got my contact details on there at the bottom. If anyone has any questions, I'd be happy to take them. I'm happy to do also a free initial consultation. So again, my contact details are on the bottom. I can book you in for a telephone appointment or a Zoom call if you prefer, or I can get you booked in for a face-to-face appointment.